Hello and good afternoon. Happy Tuesday, and I would like to welcome everyone to today's webinar, Quarterly U.S. Immigration Policy Update for Q1 of 2021. Today's session will be about 45 minutes long, and that includes an audience Q&A at the very end of the main presentation. As always, we highly encourage you to ask some questions throughout the presentation today. To do so, you can type your questions in using the GoToWebinar control panel that you see on your screen. Here's a visual representation of that. Go ahead and type that question in. We'll try to get to it at the very end. Please keep in mind, however, that we can only answer general questions on the topics discussed. We cannot get into anything company specific or case specific. In those instances, please consult with your immigration attorneys for further information. Additionally, this webinar is being recorded, and everyone in attendance will receive a link to download the recording as well as the slide deck after today's live session. You will receive those links as well as the SHRM and HRCI continuing education credits via email tomorrow afternoon. Final housekeeping note, please excuse any audio or video interruptions that may occur as results of remote work. We're not anticipating anything, but video and audio may sputter here and there, but we are not anticipating anything major. Moving along, for those who are unfamiliar with Envoy Global, for nearly 20 years, Envoy has been on a mission to fix the inefficient, frustrating, and confusing immigration process. Envoy combines top-ranked legal teams with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 100 countries, has grown 37% year over year, and we work with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And joining us today is Sarah Herbeck, the managing partner at Global Immigration Associates. She is responsible for all legal service delivery at the firm, and she and the firm's robust team of attorneys and paralegals represent multinational corporations in a wide range of industries. Sarah's practice also involves providing strategic immigration advice regarding the movement of professionals throughout the world, including temporary and permanent work visas. And she and her team work with clients to establish corporate immigration policies and procedures and provide training and supplemental education through webinars and presentations to human resources and talent acquisition teams to ensure immigration policies are applied consistently. Sarah, thank you so much for joining us this afternoon. Really appreciate it.
Thanks for having me, Eric.
Great, so we have a handful of updates that we would like to discuss this afternoon. But before we get there, I do have one more slide, just a quick legal disclaimer. And with that, let's jump into things and look at provide the quarterly U.S. immigration policy updates. Starting first, really with immigration-related executive orders since January 20th, when the new administration was sworn in. So, Sarah, on that first day, the president signed 17 executive orders, 6 of which touched on immigration. Can you provide a brief rundown on some of these executive orders and what they entail?
Yes, effectively they entail overturning certain actions taken by the prior administration. I think the headline in this one was the travel ban that prevented, certain foreign nationals from entering the United States that was predominantly that were predominantly Muslim countries. It was informally known as the Muslim ban, and I think that everybody was very pleased to see that travel ban go. Now, that's not to say that we don't have certain travel bans due to COVID, but those underlying reasons for having those travel bans in place right now is to prevent the spread of COVID and try and get our country back to looking what it did about a year ago, open and at restaurants, as we were just discussing. It also ending the border wall construction between the U.S. and Mexico, Counting non-citizens in the US Census, that was certainly a hot topic during the census. And I think that it was the right step forward, in my personal opinion.
Mhm.
Ending harsh and extreme immigration enforcement. And I think that one of the other big headlines here, we kind of buried the lead, is preserving and fortifying protections for DACA recipients. That was huge. I know this is on the deck that we're presenting today, but that is actually a part of the Citizenship Act that was recently presented in Congress. And so
Mhm.
I'm just avoiding, really calming down the fears of those DACA recipients. And enabling them to utilize a program as it was established, which was effectively stopping them from being removed and allowing for them to apply for work authorization, and then also continuing humanitarian relief for Liberians. So
Mhm.
it was a huge day, first day in office for
Yeah.
President Biden. I think just from an immigration standpoint, it was nice to see that those items were a priority from the immigration side of things. I know that the administration is focusing on many items at this time just to push their agendas forward. And I was very pleased to see, based on the immigration platform that Biden-Harris ran on, we actually saw those immediate actions take place. So,
Mhm.
cautiously optimistic from an immigration standpoint, just based on day one actions taken.
Mhm.
Since then, we've actually seen some more,
Yeah.
and have um, they too have actually had a pretty big impact as it relates to the public charge rule. Just a quick summary of the public charge rule. It was implemented and it impacted green card applications, and also was a point on certain non-immigrant petitions and applications. And effectively what this rule did, especially as it relates to green card applications, is there was about 18 pages plus worth of information that foreign nationals needed to provide to demonstrate that they would not become a public charge or had not been a public charge. It was a broad discretionary authority from USCIS officers when reviewing this determination, and having that go away, which I know we're going to talk about in a minute, and making that a
Mhm.
priority as well. Just from a disclosure perspective, anytime you file for immigration benefits, you're providing the US government with a lot of information, and rightfully so. But I was definitely glad to see that this was a priority and has since been rescinded. So
Mhm.
very good. Definitely streamlining the naturalization process. We actually had just an update today regarding certain steps that USCIS is taking to streamline the naturalization process. And actually the local USCIS Chicago office is taking part in that. So that was exciting to see. Making sure that we're getting rid of irregular immigration policies or migration policies, and establishing a family reunification task force. And we've seen a lot of that occur as of late on the news, where the Biden administration has announced that it is their plan to reunite those children
Mhm.
who have been detained for a very long time, get them back with their families, and get their families to come to the United States to get their children back so they can be reunified, which I think, again, personal opinion, but I doubt that anybody would disagree, which I suppose you could, but having children
Mhm.
be able to come back and be with their family is certainly a huge step forward.
Mhm. Yep. Thank you for recapping some of the executive orders that we've seen since January 20th. We're going to move forward and discuss some deregulatory actions we've seen since then. This is just a high-level bulleted list. We're going to go into some detail on some of these items in just a few slides, but I guess Sarah, these deregulatory actions came pretty soon after the executive orders.
Mhm.
Some of them, as I mentioned, we're going to discuss in a little bit more detail, but I guess just kind of, recapping some of these actions. What have we seen since January 20th?
I think the big headline, and which is very appropriate given we are now in the middle of the CAP registration process right now ends on March 25th at noon Eastern, is the fact that the prior administration had proposed changing the way that H1B lottery CAP petitions, were selected. In prior years and this year, all H1Bs were submitted and they were randomly selected. The prior administration proposed making it be a wage-based selection process whereby the highest wage earners would be given preferential treatment. Now, this is still in the books. They are still looking at it. I think that the idea is still out there and has some strength, but I am happy to report that it does not impact this year's CAP. CAP selection will be random, and it will commence after registration closes on March 25th at noon Eastern.
And I'm actually going to move the slide forward, which has just a little bit more detail on everything you just mentioned.
Okay.
So I guess speaking of this, what should we be on the lookout when it comes to this potential rule?
Well, I mean, I think that it's really going, I think sort of how fast or whether they push this through will really be contingent upon how, whether or not the Citizenship Act gets pushed through, because there are certain components of that that would alleviate the need for H1B caps, specifically as it relates to STEM degree holders, U.S. institution STEM degree holders. So I think that the delay was intentional, because the Biden administration is really looking forward to pushing the Citizenship Act through. And I think they're probably going to see where they've progressed before making the determination as to whether or not to pursue it. But I do know, like I said, that it's certainly still available. It has not been totally shut down by the administration. As a matter of fact, they gave DHS the authority to determine whether or not it should be implemented, which is within their authority from a rulemaking perspective. So it's not out of my mind completely, but as I can tell you, we're solely focused on this year's CAP and very pleased that it's random.
Right, great. The other big update that we wanted to discuss today, and this is a relatively recent one and one that you just highlighted a couple minutes ago, Sarah, was the end of the 2019 Public Charge Rule. So can you walk us through on how we got to this news last weekend, what this means moving forward?
Right. So we had the notification early February that this was on the list of topics and a priority for the Biden administration. There was a Supreme Court case pending to consolidate multiple district court cases where there were varying decisions as to whether or not the public charge rule should move forward, or whether or not it should be rescinded. The Biden administration contacted the U.S. Supreme Court and said that it would not defend against the public charge regulation. And very swiftly thereafter, the Supreme Court effectively dismissed the pending litigation before it. The circuit courts that had the appeals in front of them that were up with the Supreme Court also dismissed theirs, and effectively the public charge decision that placed it on hold, declaring it unconstitutional across all 50 states, was then became the law of the land. Very shortly thereafter, USCIS pulled the 944 form from its website, so it wouldn't be used, and provided guidance such that the 944 form is no longer required. The attestations that are made specifically on the form I-129 and the form I-539, the questions are there. If you answer them, fine. If you don't, you're not required to, but you can answer them if you want to effectively. They also provided guidance as it relates to requests for evidence, that if a request for evidence was issued, say as an example for the 944 for a pending green card application, that you do need to respond and say this is just no longer required, so they can kind of close a loop on that. But it became effective immediately. I believe it was March 9th. So this is very new news, and
Mhm.
we're very happy to see the swift action taken, or at least in my opinion, very happy to see the swift action taken by the administration, the court system, and then ultimately USCIS from a practical perspective.
Got it. Thank you for explaining that. And we're going to move forward to the next news item, which is that USCIS rescinded a 2017 policy memo for H1B computer-related positions. Sarah, this was another big update from a couple of weeks ago. Can you walk us through this one?
Sure thing. So in 2017, a memo was published that effectively stated, specifically, that computer programmers did not meet the eligibility criteria for H1Bs. This issue was actually brought to the federal courts. The Ninth Circuit ultimately decided that computer programmers do, in fact, qualify for H1Bs, and they reiterated that when relying upon information and documentation published by the Department of Labor, that when it effectively meets the legal standard of qualifying for an H1B, excuse me, when typically is used as a requirement for a bachelor's degree. That effectively means normally, and the legal requirement for an H1B is that a position normally requires a bachelor's degree in a specific or related field. And the government's response, in my personal opinion, was a bit convoluted, and the Ninth Circuit did an excellent job at really explaining the rationale as to why typically and normal are pretty similar. I think most of us would agree to that. And by shutting down this memo, they actually also published one that mirrored the Ninth Circuit Court's decision. And my hope is that while this is specifically related to computer programmers, the application of the Ninth Circuit's analysis and the underlying memo that USCIS published is going to help us get back to what we would expect from an adjudication standpoint, that from a legal standard standpoint of having H1Bs move through when we can demonstrate that a bachelor's degree, say in computer science, is normally required, and we can utilize the Department of Labor's evidence that is searchable online, and really be able to fortify and strengthen the H1Bs and hopefully see a reduction in RFE rates as it relates to H1Bs as well. Those have skyrocketed over the last several years, and my hope is that that we'll see a shift. And we'll be able to have a little more predictability when preparing and filing H1B petitions.
All right. And speaking of RFE rates, if there's a lot of detailed information on USCIS's website at uscis.gov, and then if you navigate to the immigration and citizenship data, they have spreadsheets of the RFE data, which is, to your point, Sarah, interesting to look at and kind of see those detailed numbers throughout the years. Moving along, and this, as you mentioned earlier, we are currently in the middle of the H1B Electronic Registration CAP registration, which opened on March 9th. And Sarah, as you mentioned, it will close on March 25th at 12 p.m. Eastern. Anything additional to add about this year's electronic registration season? How does it compare to last year's, which was the first time the electronic registration was implemented?
I think the most notable difference this year as compared to last is it's a shorter time frame. Last year, we were given from March 1st at 12 p.m. Eastern to March 20th, 12 p.m. Eastern, just due to notification requirements from a federal notification standpoint, and the administration deciding what to do with the wage-based cap selection process. All of those notices were pushed back a bit, and so our timeline to register is shorter, not by a lot, but you know, when you're when you're registering quite a few H1Bs into the platform, and the process, especially when you're working with attorneys and, you know, our clients, involves some administrative work from our client side, which is typically we take care of everything, right? But it involves our active participation, just like it did last year. Making sure that you meet those timelines and stay on top of the registration process is critical.
So I guess quite general question, what happens once electronic registration closes on March 25th? What are the next dates our attendees should be aware of?
USCIS has stated that they will make all of those registrations that have been selected into the CAP notified by March 31st, so that H1B petitions will start being accepted as of April 1st, which is the traditional day that H1B CAP petitions are accepted by USCIS.
Got it. Great, thank you. Next update is President revoked the previous administration's immigrant visa suspension. And Sarah, this is another one that you alluded to earlier. Can you explain this one in some more detail?
Sure thing. The prior administration had placed a travel ban on all immigrant visas coming into the United States. And so if you were abroad applying for an employment-based or a family-based green card to enter the United States through consular processing, all of those applications were placed on hold. Considering the fact that there are limitations to the number of visas that can be used every year, and I know we're going to talk about that again in the Citizenship Act section, you know, immigrant visas were just not being used. They were all of the processing stopped. This immigrant visa travel ban was also associated with a non-immigrant travel ban, the 152 that's mentioned at the bottom of the slide. That is still in place. That specifically relates to L1, H1B, and Js as it relates to our practice. And certainly a national interest exception process has been put in place by the State Department to see if you qualify to be eligible to get around those travel bans. But this was certainly a welcome update from the Biden administration in revoking at least the immigration component of the process. And certainly, I'm sure, much like our green card applicants and our immigrant visa applicants, are very pleased that the public charge rule is no longer in existence. So the extra burden of additional applications and documentation will not be there.
Got it. That's going to bring us to our next slide, which we've kind of combined into one, just some recent updates as they relate to COVID-19.
Right.
And obviously there have been a ton of updates, and we have a dedicated resources center for that. Actually, I mean, Sarah, you talked about it a couple of minutes ago, but it really was almost about a year ago at this time. You know, we all want work from home, and I remember us putting together a presentation, and we had technical difficulties. So I think that also just goes to show just how far and how used we've gotten to holding these webinars with everyone being remote. So we have 3 updates here that relate to COVID-19, and one of which you alluded to a couple minutes ago about reinstating a COVID-19 travel ban, except that one added South Africa to it. Is that correct?
It did. I think, again, if you watch the news, you'll be very aware that the Biden administration is very much focused on the containment control and hoping to stop the spread of COVID-19. So they did extend that travel ban and included South Africa. Right before the prior administration left, they had actually rescinded that travel ban, and effectively right after the new administration came in, they were like, no, we're not going to rescind that, and we're going to add South Africa. So I think it's very clear that restricting travel in an effort to curb COVID is a top priority. The one nice thing that we have seen out of USCIS and even the Department of Labor is that if there is a request for evidence issued, say in an H1B petition case, they're actually adding on additional time to respond. Just coordination, getting the information. You have people working from home and information is not as easily accessible. And so having that flexibility has been nice. And sort of one of the bigger headlines out of COVID is the Department of Labor used to issue perm applications in this blue paper. And inherently, we would get the email notification that a perm application was certified. And then about 2 weeks later, we would get the certified perm application in the mail. They have stopped doing that and are now issuing certified perm applications electronically via email. And this is a huge positive takeaway. Just from a procedural perspective, it makes things faster. Everybody's aware of the records. Clients and attorneys are copied. And so there's just a lot more transparency in that process. And so if there's one positive thing about a global pandemic, it's the Department of Labor has made it easier to receive certified perm applications. And I'm going to take positives where I can get them. Because much like expanding the original travel ban for specific countries, the State Department also increased the scrutiny as it relates to receiving national interest exceptions for nationals present in UK, Ireland, and the EU Schengen area. Really narrowed the fields for how an individual can qualify for a national interest exception when entering the United States. And so that certainly, especially when we had some of these midstream, we had to go back and relook at whether or not, based on the new guidance, where it specifically focuses on critical infrastructure and how the State Department defines that, whether or not individuals would ultimately qualify for for these national interest exceptions that have been put in place due to the travel bans.
Sarah, as it relates to the second one, what other what's the right word for it? I guess changes have you and your firm been happy about? I know this time last year there was that change with wet signatures, but any other changes that have happened over the last couple months, over a year, that just make things easier for your firm, for foreign nationals, and for their employers?
Well, I think you hit the nail on the head with the wet signature. Not having to submit the petitions and applications with wet signatures, being able to use a copy of an original signature to submit petitions and applications has made our lives a lot easier. My fingers are crossed that this policy will extend post-COVID. It just, again, from an ease, an efficiency standpoint, has been a very nice accommodation made by USCIS, and my hope is that it's continued even after we're out of COVID-19.
Got it. And that's going to bring us to our last major update that we have a slide on for today's presentation, and that is current and potential immigration-related legislation. And we alluded to this a couple of minutes ago. The U.S. Citizenship Act of 2021 was unveiled about a month ago. And essentially, according to all reporting and just reading through the bill, this would overhaul the U.S. immigration system, but we're going to focus on the employment-based aspect of it. So Sarah, can you walk us through some of the facets of this piece of legislation?
Sure thing. I think generally speaking, I'm cautiously optimistic. I remember 16 years ago, walking in marches when comprehensive immigration reform was up in Congress. And so I'm hoping that some of these items, if not all, will ultimately be implemented. I think that, for those 11 million undocumented immigrants, finding a way to effectively have status and ultimately remain in the United States as U.S. citizens is certainly a priority of this act. and would, given our immigration program, it looks a lot like a program that was actually implemented by President Reagan long time ago, known as LULAC. And so it's
Mhm.
something similar to that. And I think it would be certainly a very unique opportunity to allow those individuals who have lived in the United States and, benefit from this act. Again, expedited pathway to citizenship for Dreamers, also known as DACA recipients, TPS, temporary protected status, and essential workers. Right now, DACA, as I said earlier, it effectively places on hold removal proceedings for those recipients and allows them to apply for and receive work authorization, but that's not an immigration status. And so this
Mhm.
would effectively allow them to have an immigration status in the United States and ultimately apply for US citizenship, which I think would be great. They're
For
also
sure.
looking at reforming family-based immigration. I think one note of those are effectively treating spouses and minor children of lawful permanent residents as immediate relatives, which I think is a nice item to do. So I'm looking a lot like a US citizen. But the employment-based immigration changes, and if anybody on the line lived through October of 2020 this year, and any of you were lucky enough to also live through July of 2007, if these changes are made as it relates to increasing green card numbers and recapturing unused immigrant visas from prior years, we're probably looking at a very busy few months on our plate. And really looking at opportunities for individuals who have been waiting for years to apply for their green cards, hopefully sooner than expected. And certainly that would be sort of the highlight from my standpoint. Recapturing those unused immigrant visas, just because they weren't used in a fiscal year doesn't mean they don't exist.
Mm.
So the rationale behind that is, I was like, well, that makes sense to me. Just a practical look at how visas are being utilized, and making sure that they all are being utilized. That was one of the reasons why we had July 2007, to get those visas being used.
Mhm.
And this would effectively and hopefully take care of that. And then I think another notable area is Regional Economic Development Immigrant Visa Pilot Program. Um, for underserved areas where they're lacking in economic development, really allowing for individuals who need immigration status, have the opportunity because they're going to underserved areas and providing economic development and relief for those areas. So
Mhm.
certainly
And
unique.
that's for sure, and it definitely is unique. And I feel like that's one we've kind of seen discussed by various think tanks and over the last couple of years. I think it's the Heartland visa is a popular term for it,
Yep.
so I think that's an interesting one. And then there's other legislation introduced in the Senate, the
Yes.
DREAM Act. What details should we know about that one?
This one was introduced a while ago. I think that some of the items are similar in nature to the Citizenship Act, but the Citizenship Act is much more broad in scope.
Hmm.
And I think it'll be interesting as to how all of this comes together. I am certainly hopeful that even if they have to break apart certain sections of the Citizenship Act and to move them through from a prioritization perspective, I get that, I understand it, but I do hope now that we are potentially positioned to have comprehensive immigration reform go through, that it will be. I think
Hmm.
that I think that it's time for comprehensive immigration reform, and it would be a very welcome update to our immigration program. I'll have to do a lot of reading up and studying as to how all this is going to get implemented, but until then, we are closely monitoring and, like I said, cautiously optimistic.
Yes. And we actually just did get a question on when do we expect this bill to be voted on. It's a great question, but just looking through some of the reporting from Politico, New York Times, AILA, there's no firm date, and kind of to what you just alluded to, Sarah, is I think reporting from insiders and from major publications does seem like breaking the bill into smaller pieces is something to keep an eye out, to keep our eyes open on.
Yeah,
but
I think that's
going
a
off of
good point.
yeah, but that's going off of that. You know, whenever a piece of legislation is passed or important policy updates, deregulatory actions, executive orders, you definitely find all of the latest at our resources hub, resources.envoyglobal.com. We work with Sarah and her team of excellent attorneys to publish these updates as they are released. So that's going to bring us to our Q&A session. So if you do have any questions on the topics discussed, please go ahead and type them in and we'll try to answer them. As a reminder, we can only answer general questions. We cannot get into anything case specific or company specific. In those instances, please consult with your immigration attorney for further information. And then another reminder, this recording and the slide deck will be sent out tomorrow afternoon for everyone to download, and you'll also receive the SHRM and HRCI continuing education credits. So with that, Sarah, one of the first slides we talked about was, and there was a bullet point, could you briefly just discuss the withdrawal of the proposed H4 EAD rule?
Sure thing. The prior administration had made it a goal to revoke the benefit for certain H1B spouses in H4 status for applying for and receiving work authorization. That we'd seen litigation on it. And the goal of the prior administration was actually to revoke that regulation and not allow for H4 spouses to work where they were eligible based on the regulation. Withdrawing that put a lot of H4 spouses at ease to know that there wouldn't be challenges to their ongoing work authorization. So that was a big move.
Got it. I'm going to kind of combine a couple of questions just regarding keeping updated on the latest on consulates that are starting to reopen or are still closed.
I think that one of the issues that we're seeing is, yes, consulates are slowly reopening. We've actually seen some pretty big movements out of the State Department. They're now allowing for interview waivers for individuals who are applying for the same visa classification. If you've had a visa within 4 years of applying for a new one, your interview should be waived. It's not a guarantee, but that flexibility is indicative of hopefully opening up more consulates and allowing for consular officers to approve and issue visa stamps without having in-person interviews. I think that, again, really focusing on COVID prevention and containment is, the prior administration said 2 years, this administration expanded it to 4. And so I think that we'll see consulates open up. We have seen, successfully individuals going in for initial visas and receiving them. It's just, as I said earlier in a conversation, immigration is an exercise in patience. And especially when we have travel bans and government offices closing due to COVID, that we will likely continue to see an ebb and flow, but by allowing for flexibility, particularly with individuals applying for visas for visa status that they've had in the past, is a good indication that we're moving towards being able to travel a little bit more freely. But certainly that is a moving target. And so it's very critical to remain updated. And certainly if you have questions as it relates to whether or not your employees should travel, reach out to your immigration counsel to ensure that you have all the information that you need to have as it relates to potential delays, visa processing flexibility, and all of those other things that can come into play as it relates to international travel these days. And I think one thing we didn't know that is critically important, if anybody is traveling internationally, anyone from outside the United States to the United States, and I know that there are several other countries that require this too, but to enter the United States, you have to have a negative COVID-19 test within 72 hours of your travel, or you will not be allowed to board the plane. So just something to, a little food for thought there.
Got it.
And I think very indicative of the administration really focused on COVID.
What's is for consulate openings, is the State Department website a good resource?
Yeah, the State Department website is a good resource as to whether or not they're opening, but understand that the caveat is as they open, a lot of the consulates are for emergency appointments only, and we've also seen individuals receive appointments and then have them effectively be pushed back or rescheduled last minute. And so moving target, but certainly the State Department is a good website to look at.
Got it. Great, thank you. The next one centers around premium processing. Any chance we'll see premium processing for H1Bs, CAT petitions, then another one, any chance a premium processing service would become available for H4 EAD applications?
There is a chance that there will be premium processing for CAT petitions this year. However, they have pulled it back in several years. I always scratched my head at that a little bit because it was such a loss of income for USCIS, and considering the budgetary concerns they had last year, this would be certainly a good way to make some money, especially since premium processing now costs $2,500. So I'm hopeful that it'll remain open, but again, no guarantee on that. EAD, premium processing for EADs is actually in the law. It was passed by Congress. USCIS has not gotten around to implementing that yet. Their most recent expansion of premium processing is for E3 petitions filed with USCIS. That was certainly a welcome relief to many of our clients as E3 adjudications have been taking quite a while. So knowing that premium processing is an option is great, particularly when you're bumping towards that 240-day mark. And also E3s are not eligible for portability. So in an H1B circumstance, employees can change employers once an H1B petition is filed, assuming the LCA is, covers that date of employment, and so does a petition, that start date. E3s are unable to do that, and now allowing for premium processing gives a little more flexibility and predictability, and also allows for those Australian citizens who are working in the United States, having them avoid travel, which I think right now most individuals are avoiding international travel. So,
Got it. Thank you. And this will be the last question, and we'll wrap things up. Heard a rumor that there may be video interviews at consulates regarding those seeking visas. Any updates here?
I just had the update regarding regarding extending consular flexibility for not having an in-person interview and being able to apply for and receive a visa without an interview if your visa has been expired for over 4 years.
Got it. Great. Well, Sarah, thank you so much for answering all those questions. And again, thank you so much for the main presentation. We'll wrap things up with that. To our attendees, thank you so much for joining us this afternoon. As I mentioned at the top, we will be sending out the recording and the slide deck and Sherman HRCI continuing education credits in a follow-up email tomorrow afternoon. So please keep an eye out for that. And for the latest policy updates and more, please visit resources.envoyglobal.com. Thank you all for joining us. Have a great rest of your day.